Eliza Orland's career public defender for 15 years in Manhattan. And here's how one court stopped the military from being used as a domestic police force. As you all may remember, in June 2025, Donald Trump deployed 4,000 National Guard troops and 700 Marines to Los Angeles during immigration enforcement operations. But they weren't just protecting federal buildings. They were pulling people over, setting up roadblocks, doing crowd control in a law enforcement capacity. And there's a law that says the military can't do that. It's called the Posse Comitatus Act, and it was passed in 1878, and it was designed to keep the military out of civilian policing. Well, the court in Newsom v. Trump found that the troops weren't only in LA, they were over 100 miles away. They were conducting drug raids, staging shows of force in public parks, and Trump was already talking about sending them to San Francisco, Oakland, Chicago, New York, and more. So federal judge Charles Breyer recognized what was happening and he stepped in. He ruled that the president cannot stretch protecting federal property and personnel into a blank check to use the military for policing. The court called out systemic violations and shut down the administration's attempt to carve out a massive loophole in the law. This injunction stops military law enforcement in California and makes clear that the same abuse of power won't fly anywhere else. Without this ruling, we could be looking at federal troops patrolling American streets from coast to coast. Sometimes the legal system does its job. Today, it held the line between military and civilian authority, and that line is what keeps our democracy intact. Wanted to share the good news with you.